We're going to do this morning the legal version of speed dating. So we're going to talk about a whole bunch of different topics of recent changes and stuff that's out there. Some of them you might like, some of them you might not like. We don't have to talk about the ones you don't like, but the ones you like, we can have some questions and spend a little bit of time with. But the idea was to at least get you some materials that gave you kind of a high level overview of kind of everything that's happened over the last really 4 or 5 years, if you think about it. And the one thing we found is, during COVID, we had like all these new workplace rules and temporary orders and all this stuff. And employers were people were really plugged into figuring out what we could do and couldn't do. And then the legislature in the middle of all that passed all these new employment statutes in Virginia, and we had all this stuff. And I think people kind of got burned out on it. And so what I see now is people kind of like, all right, we're back. It's done. Everything's calm. I'm going to go back to running my business and not pay attention to all this legal stuff for a while. And I'm amazed that some of the more recent changes, people don't really have a great idea that stuff has changed or what's out there. So we're going to kind of walk through a bunch of that. We're going to talk a couple things. On the federal side, they changed who you have to pay overtime to and who you don't. So that's kind of a good thing to know if you own a business. So we'll talk about that for a couple minutes. The recent changes in Virginia laws kind of be a recap. Mostly have a bunch of statutes that were passed, but not all with the same effective date, sort of during that COVID 2020, 2021, that sort of time period. But a lot of those, it's interesting. There's a lag, I think, both of people being aware that stuff has changed, and then also the plaintiffs' lawyers realizing that there's something new out there that they can sue you for, because that's kind of what they're in the business of doing. And so we're going to run through some of those fairly quickly. And then we've got kind of a top 10 list to wrap it up for the last 20 or 30 minutes of stuff that I see, particularly small and medium-sized business owners. It's kind of one of those ones, you might know 8 out of 10 of them, but if you pick up one, you're like, oh, wow, I didn't really know I need to be thinking about that. Then maybe there's some value in that. So we're going to run through this stuff pretty quick, but please stop and we can chat about any of these there's interest on, and some of the others, we'll kind of run through it. So the big one that it's interesting, the first time they tried to raise the salary level for who got overtime and who didn't. Anybody remember when that was? So everything before COVID is just out in the ether somewhere, right? They actually first started talking about it in 2016, and they got struck down like 2 years later. But there was all this uproar and there was a lot of visibility around it, and then ultimately it never happened, and everybody kind of forgot about it. So then when they did it again, they went back through and passed a reg and said we're going to increase it starting July 1 of 24. It really didn't get all that much press. You really didn't read a lot about it, even though the change, it's not dramatic really this year because the change is not huge. I think we're at just under 37,000 before. We go up to now it's just under 44. But January 1, it goes to almost $60,000 a year, and then it's going to adjust over time. And so what does that mean? And we'll talk about how the rule works in a little bit of detail. But the bottom line is, if you've got anybody as of January 1 that's not making over 58,656 a year, then guess what? They get paid overtime, whether they're salaried employee, whether they're doing an exempt job, no matter what. And there's very few exceptions to that. There's a special rule for computer programmer people and a few little nits here and there. But by and large, most of the people that work for you, if they're below that, you're going to either have to start managing the overtime so they don't work it, or you're going to start paying them overtime. And here's the rub of this. A lot of us, if we have a salaried employee, we probably aren't tracking their hours, and we don't really think about it. And the Department of Labor's view is, as these regs kick in at the 43,888 number now, and then at the 58 number next year, if somebody's below that, then you don't meet what they call this salary threshold to be salaried exempt, and you're obligated to track their hours, just like an hourly employee. And if you don't do that, that's a violation, and they can fine you every pay period for not doing it. And generally, they don't do that. What they do is say, you're going to pay the back tax and not fight with us, because if you don't, we're going to whack you with all these fines. And it's a pretty effective system they've really got going. Because, and particularly if you're a larger employer, if you think about it with one employee, gee, I've been doing it wrong for 6 months. So I've got 12 payrolls and a couple $1,000 fine, not a real big deal. But if you're a bigger employer, and you do it for a year, and you got 10 or 15 people, and you've got 100 violations, if you're paying weekly or biweekly or whatever, right, you're not tracking it, they can assess you 26 violations a year per employee and go back and tax you with that. So it's kind of a bad thing to get wrong. But I noticed that this didn't get a whole lot of press. And I think the reason for that, if you look at it, was there was a bunch of litigation again, and everybody was waiting to see, is this rule actually going to go into effect? And this last time it happened, a court in Eastern District of Texas struck it down, imposed a nationwide injunction from it going into effect. They fought over it in the courts, and eventually they kind of gave up, and it never happened. And I think everybody thought, well, the case is back in front of that same court, in front of the same people, with the same argument that this is not proper. This is going to go away. We don't really need to worry about it. And they set, like, for the week before, I think on the 28th of June, the court had a hearing and a ruling and all this stuff in this Texas case. But what the court did there was they said, yeah, we're going to enter an injunction, but only as to the state of Texas, because the Texas Attorney General had brought one of the cases, not to any other private employer. And a lot of even employment lawyers were really surprised, and maybe shouldn't have been, because one of the things that happened, and if you follow all the stuff that's going up, Supreme Court's had a lot of change in how they're looking at some issues and what deference they give to administrative agencies. And there's a bunch of cases around that. And one of the pushbacks that has come down from the higher court is that they don't like these nationwide injunctions, because what's happening is people that don't like a statute like this, they forum shop, right? They try and find a judge that ideologically they think agrees with their position on this issue. Well, the DOL needs congressional authority to do this. They can't do it on their own. And so they go to that court and file. And then that judge enters an order, even though his court only covers, part of one state or two states. They get an injunction nationwide, and then it goes all the way up through the courts. And there's been a lot of that over the years, and it's grown. And the courts have said, wait a minute, there's a rare instance where that's really not how the system's supposed to work. The idea is, if the court here in Virginia makes a ruling and the court in Texas makes a ruling, ultimately those go up on appeal. And if there's a conflict and the courts aren't coming out the same, then the Supreme Court resolves those and says, we think the Fourth Circuit's right and the 10th Circuit's wrong. Have a nice day. We don't want judges basically gumming the works nationwide anytime you can go find a judge that's friendly to you. And so what happened here is it went into effect. How many of you read in the newspaper that this went into effect July 1? And it's a pretty big change. And so we're seeing I think it's almost like fatigue of all this stuff, but it's out there. I've got my first company that is in the middle of a DOL audit. And interestingly enough, they were being audited originally for whether they were properly classifying folks as employees or independent contractors. But they came back after this, and they're in the middle of it, and they sent them a list asking for a salary listing of all these people, of what their gross weekly wage is, starting July 1. Well, why would you ask about starting July 1? Well, because of the statute. And so they've added that basically to their review list. Now, are most of you going to get audited this year? Probably not. Do you have the risk if you have an employee who's unhappy or leaves or whatever, right? That if you're not doing this right, that's where the risk is. And so the statute that this stuff is under is called the Fair Labor Standards Act. And the Fair Labor Standards Act, plaintiffs' employees love. What makes a plaintiff's employee love a statute? Anybody guess? If it gives them attorney's fees, because then it means it doesn't matter if you only screwed up to the tune of a few $1,000s. I maybe can get tens of thousands of dollars of attorney's fees if I'm the attorney and I sue you. And that gives me a lot of leverage to make you settle. That they say, look, even, you're on the hook for all of my attorney's fees that are reasonable. And the court has to give me a reasonable fee under the statute. So I'm going to run my bill and I'm going to work this thing up. If you want to settle, give me a call. Otherwise, this will be great fun. And the math and the risk reward for them, right, is much better than it is in a typical case. They're not limited to getting a third or 40% of whatever you recover. They get all the money, give it to the employee plus interest, and then they get you to pay their legal bill.
Is that for gross pay?
So it's gross. It's gross before deductions, and you can include bonuses and some other comp. And so you can include things like that get paid out. Expense type reimbursements that are cost expense reimbursements don't count, but it is a pre-tax sort of gross number. So this thing's gone into effect. There's still some hope that one of these other courts will still enjoin it. Whether they'll do it on a nationwide basis or more limited, I think people are a lot more doubtful. And I think also, like, the pressure on a court to do something right before something goes into effect to stop this bad thing from impacting all these employees. Well, once it's been in effect for a few months, right, I think that kind of wanes a little bit. So we may well be stuck with it. There's a lot of people still pushing to try and get something done before the higher limit in January kicks in. And there's one, there's one case on appeal up in front of the Fifth Circuit that Justice Thomas has said, I think their view of DOL's authority on this issue might be right, and put that in a footnote in another case. And so people think maybe that case will get taken. But even if that happens, Supreme Court doesn't act that quick, right? That'll be a while. And so for the moment, we got this rule to comply with. And so we want to be thoughtful about that. So then I thought, what's the best way to explain something that doesn't make a lot of sense? I love charts. And I need to get better at doing charts. But I played with ChatGPT and I made this little chart And it's not perfect, but I'm learning how to use it. So basically, this is kind of, and I do this more as kind of a thought exercise that if you go through and start thinking about an employee you have, right? Are they exempt? Because there's two sides to this, and a lot of us forget about this. There is a shorthand test that if they're doing some exempt work and they're making six figures, that there's kind of a short test that you don't have to show that they're spending the majority of their time doing exempt work. But for most of us, most of our people we're wondering about aren't making six figures a year in our part of the world, right? So we're under the regular test, which basically follows this for most types of jobs. And so we go, okay, are they managing the business, right? Easy enough. The president, your manager, all that kind of fun stuff. That works. So we say yes. So we then say, well, what are they doing? And so really, generally, that's if you regularly supervise two or more employees or some division of the company or some operational party, and you've got real authority to run that part of the business or to manage those two employees. And most people that aren't senior, kind of higher level management meet this test by being a supervisor that has two or more full-time equivalent employees reporting to them. And the test then is their primary job, the reason you have them there, to supervise these people. And there you have to be careful, because if their main job, I'm working at the Burger King, right? There's two kinds of people. My main job may be to run that restaurant, but during the morning rush hour, I may go put on a headset and go help and serve some food. But the reason my job is there is to run that restaurant. The rest of the day, I'm managing the staff and doing all the other stuff and make sure somebody clean the bathroom and getting the schedule set for next week. And so that I'm an exempt guy, even though I might spend part of my time right doing stuff, running a factory, manufacturing a widget, or serving customers in a retail store, whatever it is. So the question is, what is the job there for? You can do both. But the primary duty, the main reason you're there, the thing you spend most of your time has to be kind of the stuff that relates to running the business, not, cooking a hamburger or whatever it might be. So to get that, you're an executive. Congratulations, nice job. If you're not, then you have to go over and say, all right, there's also an administrative exemption. And there probably ought to be one more arrow, but you can go over and kind of look at that one as the other kind of managerial one. And that says, I'm doing office or non-manual work related to management or general business operation. And what's that? That's my HR manager, right, for a business. They're not making a widget. They're not serving customers. They're not making my product. What are they doing, right? They're managing some aspect of the business. They're doing something that goes to the overall running of the business. My CFO, right? They might be doing that. An office manager that actually has some authority, right, to do stuff can meet in that. And so if you've got and this is an interesting one, is my legal assistant an exempt employee? No. But you can have an executive assistant office manager who you give enough responsibility to that they meet this test. And the test isn't, are they doing that support stuff? It's what? Then they come in and say, are they spending 51% of their time doing stuff that really takes the regular exercise of discretion and independent judgment? And that's not what kind of pens to buy, or, whether to get the toner at Office Max or through Amazon, right? It's things that are actually, you give them some authority to make decisions and kind of run stuff in your business. And if you really do give them some meaningful authority as to certain aspects, maybe subject to your review and control still, but some meaningful judgment and discretion. And the example I give there sometimes is a ledger bookkeeper. And the only thing they do is record everything that comes in and everything that goes out, and they get the bank statement and they see if they match up. Is that judgment and discretion? No, that's really kind of an administrative task. So even if they've got a CPA, they're not exempt. But my controller, right? Or if I've got somebody and I also have them doing budgeting, doing forecasting, right? Doing other things, they've got some authority to approve vendor contracts and payments up to a certain dollar amount. Now I've given them some authority. And so the question is, are they spending most of their time doing stuff that requires some of that authority? If they only do that, 10% of the time, the DOL is going to say, yeah, we don't like that. If they're spending a fair amount of their time doing that kind of stuff, then you can say, all right, I think that's an administrative exempt employee. I'm good. And then you say, all right, well, if they don't meet that, what can I do? Then you have over here primary duty work requiring knowledge of an advanced type. That's an engineer, right? That's a biologist. That's a lawyer, right? Those are your professionals. So you can get the professional exemption if you're down on that side. Generally, you have to either have something that requires some sort of terminal degree. Could be in the medical field, that sort of thing. Could be a doctor, could be a lawyer, could be an engineer, could be a surveyor with a master's in a certain type of, but it's got to be something that's qualified, and you can kind of look at that. And if you get outside of that, there's this fun one down at the bottom that I almost never deal with. And that's, I want to do this someday. I want my primary duty to be using my imagination and inventive thoughts and talent and artistic stuff. Nobody's ever wanted to pay me to do that, but you can meet it on that too, interestingly enough, if you're a creative professional. And if you're not one of those, even if you're above that salary threshold, you still get overtime. Even if you're making $70,000 a year, it doesn't matter. And so you have to fit into kind of one of these buckets. There is a separate test for computer professionals. The only thing I'll say about that is that it's a shorter tree that's easier to look at. But if you look at that test, the mistake I see people making is thinking that anybody that does computer stuff, anybody's in IT, right? Well, they're a computer professional. They know this computer stuff and I don't. They're better than me, right? I don't know how this stuff works. And if you look at this test, the person that makes sure your copier works, that I'm connected to the network, or right, that sets up the projector in here, right? They're doing IT stuff, but they don't meet this test. They're not programming. They're not designing networks. They're not right doing all that stuff. But like your IT guy that decides what kind of network and router and runs it and designs it and does that overall stuff, or is actually doing coding or integration of a piece of software into your system, like that kind of stuff, that's a computer professional, right? It's coding, it's building equipment, it's designing a system. So, a CIO, you got to be a reasonably high level professional or be doing programming. Any type of programming will kind of fit under that. And so I see people put a lot of folks in this bucket that don't always fit there. They're fairly reasonably well paid. So we see that sometimes. And there is a different hourly threshold, salary threshold. So if you get into having a computer person who thinks in the bucket, if you just Google FLSA computer professional, there's a cheat sheet that walks you through what you need to do for that IT person to meet the test. But it's a little stricter test than people think. The other side of the test is, even though you pay someone a salary, the starting point in the old statute is basically this idea that you got to get a fixed salary every week. And so one of the ways you can also screw it up, even if you pay someone well, is to deduct stuff you're not supposed to deduct from their pay. And you're only allowed to make certain allowed deductions from somebody's fixed salary. And if you make ones that aren't permitted, then you can blow the exemption and be required to owe that person overtime as well. The old rule on this, until about, probably almost 8 or 10 years ago now, but you still read stuff that says this, was if you messed it up, you could lose the exemption for a whole class of employees if you did it wrong for some. And it was really a draconian, if you're a bigger company, a really dangerous test. Now, basically, if you do it wrong, it's only the people that report to the manager who was treating people wrong. I mean, it's so much more limited, but in a smaller employer, it can still be a really, really big deal. So the base idea is, hey, I get my salary and it doesn't matter how hard I worked this week or how good my work product was, right? If I worked some for you this week and I'm a salaried exempt person, it really doesn't matter if I did 30 or 42 or 50, I get my full salary, but I don't have to get paid if I don't do any work that week. And that was the original regulation. And then over time, they said, well, this doesn't really make a lot of sense. There's probably other stuff we need to allow people to do. They don't FMLA leave, and it's not paid FMLA. Well, does that blow their exemption because they're taking? And finally, of course, we need to start thinking about some of that stuff. So basically, they've said, we're going to come up. If you're ready, willing, and able, you got to get your salary, but we're going to give you a list of some things you can do. And the list isn't bad, but it's pretty well defined. You're absent for a personal reason other than sickness or disability. What's that? My kid's school is going to, Busch Gardens and I want to go. And you're like, well, okay, I don't have to pay for that. Now, if I've got paid leave, that's fine. But if I don't, and I just say, well, I'm not coming in on Friday, I'm going on the field trip. I missed the whole day. It's personal, right? You don't have to pay me. Seems obvious enough, right? But remember, full day. So what happens? This is where you get smart, right? This is what I would do. I want to go on the field trip. The bus not leaving until 10. I'm going to come into work and work from 8 to 9:30. And they're like, well, you don't have any leave. And you say, I don't care. I'm going on the field trip. I still get my full salary. Now, you could discipline me for not being at work, right? And not having approved leave, but you still got to pay me, believe it or not. And that's the one I see people getting in trouble for. Happens all the time, right? I've got a transport issue. I'm sorry, I got to go. Or I need to go take care of something. And they leave at lunchtime. They say, well, I'm just not going to pay them for the afternoon. Believe it or not, if they're salaried exempt, you can't do that. And that surprises folks. And then you go down to sickness or disability. And the exception there is, right, obviously, if they're getting paid, if you provide sick leave or PTO, you can charge it against it. They're still getting their full salary. But under this exception, basically, once they're out, right, if I had 10 days of PTO and I've already used them, then I can deduct those sickness days because I have a plan that provides a certain amount of sick leave. So why penalize the employer if people go over? It kind of becomes meaningless, right? If they're unlimited paid, then what's the point of it? And so they do allow an exception for that. If you're out and you get jury duty witness fees, you can actually make an adjustment. Almost no one does that because the amounts aren't very big. And it seems kind of, do you really want to go through the hassle of saying, well, I'll give me your receipt for your $26 of jury pay, and then I'll deduct it from your salary and we'll make a thing in accounting. And like, nobody does it, but you're allowed to do it. A safety rule of major significance, right? If I'm not supposed to drive the forklift drunk and I drive the forklift drunk and you suspend me, you can actually penalize me and deduct my pay. but it has to be a major safety rule, meaning one that could result in injury or serious. Like it's got to be serious stuff. It can't be kind of piddly, right? I caught you not wearing your safety glasses out in the parking lot, and so I'm going to dock you a day's pay. You can't do that kind of stuff. And so you go, okay. In good faith for workplace conduct rules, you can do it, but again, it's got to be full day increments. And so if you send them home half day on Friday, they still get paid, even if it's a disciplinary suspension. But if you send them home Thursday and say, don't come in Friday or Monday, I'm suspending you for 2 paid days, then you can dock it. FMLA, of course, is out of there. And then this is the last one they put in because plaintiffs' lawyers were having great fun with this. So until, believe it or not, until I think it was 2016, if you hired somebody, people don't always start at the beginning of your work week, right? Sometimes they start Monday, your work week starts, whatever it might be. And a lot of times if they quit or you fire them, it's not always effective the exact end of the 7-day work week that you've selected. A lot of times it's somewhere in between. And of course, people wouldn't pay people for those, right? I fire you on Wednesday because you're stealing from the company and I catch you or you beat up your coworker, whatever it is. And I say, you're out of here now. Well, I actually would still have to pay them. And so nobody would do it. The plaintiffs' lawyers, when they got mad and innovated their claim, they would say, you violated the FLSA because you didn't pay them their full pay. So give me some money or I'm going to bring this claim. You're going to pay my attorney's fees. And so they got rid of that. So that was kind of helpful. Yep.
From the chat was for comp time, how does that impact overtime?
That's an awesome question. So the government doesn't trust private employers. They trust public employers to not take advantage of their employees. And so you hear about comp time because it's very common in the public sector. There's a different set of rules for public entities. They can up to a certain number of hours, depending on the firefighters, it can be a larger amount, but generally speaking, they can do some comp time to an employee, right? You had to come in and work Saturday, so take off next Wednesday or take a free day end of the month and add it to your vacation. And isn't that great? And won't pay you overtime. Private employers are not allowed to do that. You can only do comp time within the same work week, which means if they go over 40 hours in any work week, they get the overtime. It's not by pay period. And that's the most common violation when they do audits is people look at that, a lot of people pay them 2-week increments or whatever it is. And if they're above 80 hours, they pay them, right? But if they work 50 hours this week and 30 hours next week, they say, well, they're not over 80. Well, they get 10 hours overtime the one week and they get 30 hours of straight pay the next. And so that gets fouled up a lot. And so private employers, comp time really just means within the same work week, you can move some work around a little bit. Now you can pick a work week that works. I've got a couple clients that are very heavily loaded that, their shipment to their stuff only goes out on a certain day of the week. If they're not ready, right, they got to work overtime. Truck's going out 4:00 Thursday to go to our customer. And so we actually move their work week so that if people end up working 10 or 12 hour days, those 2 days before their peak day, then we can say, well, just don't come in tomorrow. Right. And we're still in the same work week, or don't come in Monday because that's going to be a slow day for us because we made you come in Saturday. And so you can choose a week. You just got to stay with it. You just can't move it every week, right? To save yourself money. So we have that kind of stuff out there, which is kind of interesting. What happens if you get it wrong? The rule now is not nearly as bad. Basically now, if you find out about it and fix it, employees in the same classification for the same manager, they'll look at that group and say, pay all those people whatever wasn't done right, and you can keep the exemption. If you do it repeatedly or willfully, then we're gonna say you're paying them overtime going forward. We're going to disallow you. So that's a lot better than the old rule. So you look at the good faith compliance, all that fun stuff. And so inadvertent stuff is not a brutal penalty as long as you fix it when someone brings it to your attention. So they say you need to have a policy. They don't say it has to be in a handbook, but that's obviously a pretty good way to do it. Because if you do that, nobody can, they get a sign off on the handbook, all that fun stuff. And so what does the policy do? Basically, it says what type of stuff we're going to do and tells you to come tell us if you sort of have an exemption. And so there's stuff you can do. You still get to set the schedule. You can make changes. I mean, you can do a lot of this other sort of stuff that's out there. You can make somebody track their hours, even if they're exempt. And we have a lot of large companies do that for folks that are salary exempt, that they think there could be some gray or somebody could make an allegation later that maybe they weren't, because then we'll at least have the record. Because if you come in and they audit you and you don't have records for an employee, right? You thought they're salaried exempt, right? You didn't realize something here had changed. You're still paying them a salary of $45,000 a year going on with life. Well, you're not making them punch a time clock. They're doing their job and they come and go. So what do? They say, well, you don't have records. So what's the best source of information? We'll just go ask your former employee how much they thought they were working. And, my experience is that people have a generous view, particularly after they've been fired. of how much they were working for you and how many often they go through where you're required to respond to emails after hours or take phone calls. We'll include that time, right? I mean, all that kind of stuff. Did you ever take work home to read for the meeting the next day? It's anything they do for your benefit. Respond to text messages. And so then they ask people that, and then the people say, oh gosh, well, gee, if you include all that, I was probably working 45, 50 hours every week. And they'll say, okay, wonderful. We're going to add that up for 2 years and we're going to send you a bill. And that shocks people a lot of times when it happens. And so it's one that is, and listen, if you're not doing it, this is people get this wrong all over the place. And the idea is if you do, just fix it going forward, kind of go out there and kind of move forward and kind of get yourself where you want to be. Under the old rule, you'll still see stuff written sometimes that says things like, don't voluntarily pay overtime or extra money to somebody who's salary exempt, or you're going to blow your exemption. And in the old days, that was true. One of the factors they could look at is, well, wait a minute. If you're voluntarily paying if they come in on Saturday and go over 40, doesn't that make it seem like, right, they're hourly or something? And they changed that rule and said, we're not going to penalize people for doing that. So if you want to pay people when they work extra hours, even though they're exempt, nothing wrong with that. And I've got a number of clients that are like professional service firms that say, look, sometimes our engineers, our architects, people when they're busy have to work. And we want that to be equitable for how people are getting paid. If somebody's on a project where they're working 60 hours a week, right, they ought not get paid the same as somebody who's not real busy and only working 38 hours a week. And so they allow you. So some of those companies will say, well, there's a little bit of leeway, but if you're above 45 hours of client time in a week, we're going to pay you extra money for that time. And that doesn't mess up your exemption. Nothing wrong with doing that anymore. And so we've started to see some employers do that. So any questions about that? We're going to talk on about that's the biggest change we've got sort of on the federal side that you want to be aware of. And I think it's going to have a lot more impact come January 1. And people say, well, what do I do if I've got somebody that's close? And what we're doing with most of our clients is sitting down and saying, all right, well, you got two choices. You can give someone enough authority that you're comfortable, right, that they're spending 50% of more than half of their time doing exempt work, give them some authority. You can change the job to make it exempt, nothing wrong with that. You can also change the job to make it not, right? You can bump them above the salary limit if you want. You can even, if you want, say, well, gosh, this is hourly. You do work overtime. I've got to start paying you overtime in January, but I can't justify a $60,000 a year salary for this job. Not when our workload does this. I'm going to move you to an hourly rate that might be less than if I took your current $50,000 salary and divided it out, because I'm going to anticipate that you're going to get a bunch of overtime some weeks. And so I've got to build that in because I'm going to pay time and a half. You'll say, well, can I do that? Yeah, you can do it. Is your employee going to like it? No, they're not going to be very happy about it. So you got to kind of decide, right? Is it worth it in your business, right? Is that a model or a conversation that how do you handle that from an employee relations standpoint? But you don't want to go out and not be compliant with this stuff sort of long term. I think what we're going to see is DOL, every time they do an audit, they're just going to start asking for this list. And we're already seeing them do that. So we want to be sort of thoughtful about that. Yes, sir.
Did I see where salespeople are exempt? You're heavily commission based.
So this is a great one. Outside salespeople are exempt. And so most of my job is being out, calling on customers, seeing people going out, and I'm commission based, there is an exemption for those folks. The place people get into trouble is it does not apply to what they call inside salespeople. And so if I'm doing a job where I'm mostly at my desk, but I do some sales from there, but I primarily work in an office, I don't get the benefit of that exemption. But if I'm a person that's just out doing commission sales work and I'm making most of my money from that, there is an exemption there. But you got to be careful of designing that job so they meet it. And you'll see that's why some places that are heavily commissioned in certain industries and financial services, some of that, they intentionally design the job to make those people outside salespeople. You don't get an office. Here's the stuff you can, and they're doing that intentionally because they want to reduce the risk that person gets determined to be an inside salesperson who's doing some sales, but really is an office worker, and that they really are somebody who's just out selling. And so you do be careful, but there is an exemption for that. That's correct. And there's some other stuff you get into salespeople. There's statutory employee exemptions that are slightly different for certain type of sales reps and things like that. So there are some wonky rules for that, and some different rules for how you treat them as a employee and what benefit plans you put them on and some things you can do, but that gets a little more complicated.
Another question, is there a regulation on overtime paid dollar amount?
So it's just time and a half, whatever. So if you pay them a salary, they're going to take that, right, divide it by the number of hours a year, or whether, if they're at a 40-hour, whatever, they're just going to reduce it to an hourly rate. And whatever that hourly rate is, they get time and a half for overtime. So, if I'm getting paid, $30 an hour, my overtime rate for the hours above 40 is going to be 45, right? It's going to be time and a half above that. And so, but you only get that for hours actually worked. And so this becomes an issue if you have paid vacation days. And so if you've got a day, right, that there's 4th of July in the week, and so you're only scheduled for 32 hours, but you're paid for 40 because we pay everybody for 4th of July. If you work that Saturday or you work late another day, you don't get credit for the paid holiday towards your hours actually worked, or vacation. If you take vacation on Monday, it's got to be actually hours above 40 that you were in the office, or that you were doing your job. So that's a fun one.
Is this a business profile that gets audited, like
No, I guess is the short answer. So what happens, the state does have an ability to do some of this. They don't do a lot of it. They just don't have the manpower. They'll do some audits. Most of the audits we see are actually coming on the federal side. The Department of Labor has an office in Roanoke, for example. They do a certain number of random, ones a year. They do over time target different industries here and there, but they don't disclose how they do their selection. So you get the random, you're just unlucky. We have found that companies that do a lot of business with the government and that are in those databases, for whatever reason, seem to come up like they know you're out there. I mean, if you're a little business, the question is, how do they even know you're out there doing business? They're not as sophisticated as you might think. Just because you're filing a tax return, they may not know. But if you're out there more, and as you get, and so certainly if you're bigger, it's more likely. But we see plenty of smaller employers get randomly targeted. And then the other way they do it, and the only way really the state gets into it very often, they do some audits that are not this, but not that many, at least around here that I see, is you have a disgruntled employee. If somebody complains and goes to them and goes to the state and says, hey, my employer's not paying us overtime, or my employer's docking my pay improperly, or any of that kind of stuff, they will write you a letter and say, hey, you need to tell us what we're doing. Just like if you don't give someone their final paycheck and you hold it back, you'll get a letter from the Department of Labor saying, show us that you're in compliance and that you're doing this right, or we're going to come down and visit and talk to some people, and they'll come in and interview people and try and figure out sort of what's going on. And so smaller employers, most of the ones I see actually relate to, often an employee that's disgruntled when they leave. They're looking for some way to bring a claim. They go to their friendly neighborhood plaintiff's lawyer and say, hey, I want to sue my employer. They fired me. It was unfair. I was a good employee. And they kind of go down their checklist of, well, is there evidence that it was because you're disabled, or, you're in some protected status? And there's not much there. So then they don't want to send them out, right? Because it's a paying customer. And those are hard to get in your office if you're in that line of work. And so then they start saying, well, what else could we do? And literally a lot of them have a checklist. Tell me about how you get paid, right? Tell me if you get overtime, tell me this. And they go through that list to see if there's something else there. And what they'll do to get leverage is they won't go to the Department of Labor. They'll write you a letter saying, you're doing this wrong. Why don't you send us some money and we'll go away. And then if you don't, they turn you in and still sue you. So they try, and that's kind of their business model. So we're going to jump over now and talk about Virginia. These aren't as new as that federal one we just talked about. That's obviously the biggest change at the federal level. But I still see some of these that people get surprised about. We're going to start kind of with the oldest one, and we're going to go through these pretty quickly. But there's a few that I think are worth maybe spending a little bit more time on. The first one that's out there is, it used to be in Virginia until almost 5 years ago now, but employment files and personnel records were considered company property. And that was the standard line. You don't have to give it to a former employee. You don't have to give it to their lawyer. Tough luck. Some employers will let you come in and look at it, but we're not going to let you make a copy of it. That's our stuff. And, here's your disciplinary notice, and that's all you get to see. They changed the law back to give employees access, but it's not unlimited access. If you look at this, what is it? Documents that show these 4 things. So obviously stuff related to an injury, and the report of that, the accident report, that kind of stuff, they're allowed to get that stuff if they ask for it. The part where it gets weird is it every document that references their job title and description? Or is it like their job description? And the statute really doesn't tell you a lot about how broadly to interpret that. And so there's still some gray there, because there's not a lot of court cases under this thing. If somebody gives you a request, they have to do it in writing. You got 30 days to respond. you don't have to keep any particular records for any particular length of time under this. And there is an exception that if you've got an employee who's, having a mental health crisis, has an issue with an employee, that providing something in there you think would endanger the employee or a coworker. So for example, if there's information about a coworker, turn them in for selling drugs in the workplace, and you're afraid if they see that memo in your file, right, that you may have someone shot in your parking lot, and you don't really want that, you can withhold that kind of stuff. So there are some exceptions there to do that. So what's the main takeaway for me is don't ignore it. If there's nothing in the file you really care about or that's really sensitive, just turn over the whole thing so you don't have a risk about what's there. If you've got investigations regarding this person, if you've got sexual harassment complaint involving them, and you've got stuff that's fairly private that you're worried about providing, that's when you want to touch base with someone, and we can determine what things we really think we need to turn over under that statute and not get ourselves in trouble. But just don't follow the old rule. The other big one is Virginia, until about 4 years ago, there really weren't meaningful protections at the state level for discrimination. Everyone's familiar with federal law, right? Can't discriminate on race, color, religion, national origin, disability, age, all those fun things. And Virginia had a Human Rights Act, but the remedies were really limited. What companies applied to was really limited, and we saw almost no cases under it. And what they did here was they expanded it, and the state statute is actually broader than the federal statute now as far as what you can get. And so want to make sure everybody's sort of aware of that. The original statute only applied to employers between 6 and 15. Below 6, there's no coverage. And the reason they picked 15 was that's where Title VII and most of the federal protections kick in at 15. Now, there's a couple that kick in at 20 and FMLA kicks in at 50, but the general Title VII, race, gender, those kind of things, religion, those kick in on the federal level at 15 employees. And so they were trying to get kind of this in between. Well, gee, we don't want to beat up on the person with, an owner and 2 employees. But we don't want these people that are under that have 10 or 12 or whatever employees to get away scot-free with discriminating. And the remedies were sort of limited. You could only get up to a year of back pay. The attorney's fees were limited to 25% of the back pay award, so that didn't come out to a whole lot. There were no compensatory or punitive damages. They couldn't ask for reinstatement, and so it was a fairly limited statute. The idea was to make smaller employers not discriminate, right? To have some penalty there, but not make it so draconian or so big hanging over their head. And that's what we had for a long time. I've been practicing employment law and defending companies in this area. I'm almost embarrassed to say that next month it'll be 30 years. I had one case under the statute before it changed, that entire time period. So it was almost never used. So then we say, all right, the legislature code says we're going to protect employees. We're going to be a more pro-employee. There was a change in control of the legislature. The Democratic majority wanted to extend employment protections and show that they were pro-employee. And so now we say broader coverage for all employers with 15 or more. So it still covers them, but that limited unlawful discharge part still applied to the little guys. But they said, as to everybody that's bigger than that, we're gonna cover all employers under the state statute as well. So now if you're over 15 employees, you can be sued under federal law or state law or both sometimes. And they expanded kind of who it applied to, even school boards and some things like that. They wanted to make clear that it's almost everybody. So what did they do with that? So they did a couple of things that were interesting. Race is covered under the federal statute. The state one was very broad, that it includes, there are a number of things that are not in the federal statute that some courts will recognize and some courts don't. So the Virginia statute got pretty specific about some things, even, employers that limit sort of hairstyles and traits historically associated with race that are related to dress or appearance or those sort of things that they're like, unless there's a real business reason, those are protected now under the state statute. And some employers that want to have strict dress codes or appearance standards can run afoul of this. And that's why you may see a little more freedom, even in your restaurants and places like that there's not quite the strictness that maybe we used to have. Because if you can say, my religion requires me to have a beard, then you can't tell me to shave my beard unless there's a real safety risk, right? If I got to wear a respirator and go into space where that's a safety risk, you can have the rule. But there's really not a safety risk in someone serving you a hamburger with a beard. So, you're going to have an issue there if it's based on, a protected thing. And same with racial characteristics, hair types, those sorts of things. So it's a statute that's pretty broad. The other thing it did is it almost jumped ahead. So the federal statute talks about can't discriminate based on gender, right? Based on sex. but it doesn't say whether that applies to sexual orientation, gender identity, some of those kind of things. They're just not referenced in the statute. So more progressive courts have said, well, if you discriminate against somebody for being in a homosexual relationship, whatever it may be, well, that's based in some way on their gender. That's related to their sex. So we think that's covered under the statute. Great. And some more conservative courts said, no, I think they meant gender meaning man or woman. And they didn't never mention anywhere in the reg, anywhere in the legislative history, it doesn't talk about any of this other stuff. Well, it really wasn't talked about in 1963, it turns out. In 1964, it wasn't, right? Wasn't looked at the same way. And that wasn't what they were trying to do when they passed that statute. They were just trying to get some basic protections during the civil rights movement. And so you have some federal, now over time, most of the federal courts are now, at least in some scope, recognizing sexual orientation, gender identity, but the Virginia statute expressly does it. And so we're seeing some places where say, if I've got that type of claim, I'm going to come to state court because I don't have to fight over whether it's really based on gender, this other stuff. I can get right to it. And they provide some additional protection if you discriminate based on lactation, pregnancy related things, some of that, and some veterans protection that are slightly different than the federal statute. Believe it or not, the federal veterans statutes, some of those protections actually don't apply to every veteran. They talk about protected covered veterans, which is very broad. People have got a service medal. I mean, there's all these different categories, but you could actually be in the military and not be a protected veteran under the federal law for certain aspects. And so the state law is a little broader. So they started to make this pretty good. And they expanded it to not just firing people for an unlawful reason, but they expanded it to hiring, comp terms, this broad, basically anything that affects them economically in their employment, which is what the federal law does. So they kind of made it consistent now with the federal piece. You think, all right, pretty good there. The difference, other thing they did, and it's a little bit hard to read on here, is the compensatory damages under the state statute aren't limited. And we'll talk about that. Under the federal law, they're actually limited based on the size of the employer. And so smaller employers, there's caps, a couple $100,000, that you can't get $1 million award against a smaller employer under the federal law. Under the state law, you can. If you could show that you have that level of compensatory. And then I added punitive damages if you act willfully or recklessly and all this kind of fun stuff. And the attorney's fees aren't limited anymore to 25% of back pay. It's whatever the judge wants to award, and they can do injunctive relief. Well, what does that mean? They can tell you to put the person back to work if they think you've unlawfully fired them. So much broader remedies under the state statute. You say, wow, this is looking pretty good if I'm a plaintiff's lawyer, right? It also includes reasonable accommodation for disabilities, medical conditions, and also for things related to pregnancy and childbirth and those sorts of things. Under the state statute has very good protection for women, and that was a big accomplishment because that's continues to be an issue at many folks. Not an unlimited one, but it's a pretty broad right, and you want to make sure you're meeting this. And we do see claims under this more in the manufacturing world than the office world sometimes, but there are a fair number of claims related to this. The place people mess this up, and particularly smaller employers, is there is this idea of determine, is there a reasonable accommodation that lets them do their job, right? If I'm blind and I want to be a truck driver, there's really not a good accommodation with today's technology that lets me do that without somebody else being in the truck driving, right? And they say, well, if you need another person to do that, right, you can't do, that's an essential part of that job, obviously. And that could be applied to all kinds of physical things you need to do in a particular job. But you have a duty to go through an interactive process. And some employers just assume there's no way I can accommodate, right, this person in a wheelchair in this job. So they just make the decision that may be right, but they don't go through the interactive process. And believe it or not, failing to go through the interactive process and at least interact with the employee, the applicant, to see if there's some way they can do it. They're like, well, yeah, I'm in the wheelchair today, but I'm not always in a wheelchair, right? And it's just because I had to have another treatment on my ankle that has bone disease, but I'll be back up and moving around oh, I didn't know that, right? And if I talk to them, well, now they just want you to limit them for the 2 weeks till they get back out of the wheelchair. Oh, well, now they got a disability, they're protected. You probably have to accommodate that. But if they can never get out of the wheelchair and the job has physical tasks that wouldn't be, and so you have to go through that process. If you don't do it, that actually could be a violation, even if there really wasn't anything you could do to allow them to do the job. And so we see that, which is a little bit crazy. So now it's gotten attractive to sue employers in state court. And the big difference here is if you look at state law, federal law, and this gets a little bit into lawyer speak. So it used to be a very favorable area for if you were a management side lawyer. So when I was doing this, and we were trying a lot of cases back, 15, 20 years ago, 70% of the cases people brought of discrimination cases in federal court, the courts were just throwing out before they ever got to trial. They'd look at it and say, basically, you could take the person's deposition, you could get them to serve discovery on, you could get some records, you could put an affidavit from, right, the manager and saying, well, no, we didn't fire them because of their gender, their national origin, their whatever. We fired them because they stabbed their coworker. And, the court just throw that out. I mean, that's an extreme example, obviously. But if you could show, the test was, if no reasonable juror on those facts could determine that their protected status was a reason, the fact that they think it is, right, I'm sure that my manager was biased against me because of my disability. Well, what's your evidence of that, right? And if if you got emails, people said stuff, like there's some evidence, they say, okay, great. But if there wasn't some evidence that a reasonable jury could say, yeah, I think that employee's onto something. Yeah, my manager told me that 3 times. I'd probably think they were biased against me too. Right? Or sent me an email that said, we don't need any more people like you. I said, well, what the heck does that mean? Right? If there was something there, but in a lot of cases where it was a he said, she said, and particularly in a lot of sort of sexual harassment, hostile work environment type cases, if there wasn't some pretty strong evidence, the courts were throwing those out. It was great fun to be a defense lawyer. You felt like you're really good. You won almost all the time. Right? So you're like, this is pretty good. But the math was 70% of the cases were getting thrown out. And the one exception was if there was a retaliation component for bringing a claim, the courts were, and still are, much more hesitant to throw that out, because the system doesn't work if I come and complain and you fire me, right, for coming in and raising my hand and saying, hey, my manager's discriminating against me because of my race. And you go to them and they say, oh, we don't need this kind of trouble. And they fire you, right? So those ones would go forward. But ones that didn't have that component, a lot of them were going away. And that was what's called summary judgment. Basically, you do a little bit of investigation of facts, you put it all in front of the judge, and the judge can decide, is there enough evidence? He's kind of a gatekeeper of where you go in the process, because obviously having a trial and this stuff's very expensive, and it's supposed to be more efficient and all that. And state court in Virginia, you can't use depositions to get summary judgment in a case involving an individual. If it's 2 businesses, you can fighting with each other. But our state legislature is mostly what? Anybody want to guess? The majority of the people in the Virginia legislature are what? Plaintiffs' attorneys. It's great PR for getting more clients. People think you're connected, and they really like making rules that serve them. So, for example, non-compete's been illegal for lawyers for years. Now they're just getting around to doing it for everybody else, right? And all kinds of fun things and things like this. Because what was happening is they didn't want personal injury and car wreck and all these kind of cases getting thrown out based on what somebody said in the deposition, because that they made less money that way. So they said, well, we're not going to allow that. Unless they admit it, you're done. We'll figure that out in trial. And so now that rule applies to employment cases in state court. And everybody thought when this happened that there was going to be this avalanche of cases in state court because they're going to be hard to get dismissed. And everybody could file, would bring one of these claims. And in state court, you're kind of, well, get a trial a year from now. We'll see what we think. And everybody will come down here. And that was going to be really bad. And I even thought there'd be a lot more of it. And what we've determined is people are used to doing what they do, including plaintiffs' lawyers, right? They're used to filing a complaint in federal court. They know the process. They know how to file a charge. They know how to file, the documents. They've got all the stuff. And there really hasn't been. And it's really not until now that we're starting to see some firms that do a lot of this really start to make a conscious decision of this is a better state court case. And there's one firm in Roanoke, it's a larger one, does a lot of plaintiffs' employment stuff. They've started using the state court system where it makes more sense, still filing most in federal court, but we're starting to see that kind of grow. And I think over time you'll see more, but it's a pretty big incentive for employers to get it right, because I think the exposure is sort of higher than it used to be. Here's one of my favorites. Nobody likes this when I talk to them about it. So it's called the worker misclassification law. And what does this do? This says if you're an employer in Virginia, you have the duty to show that somebody is an employee. We're going to have a presumption that anybody, an individual, right? So not a corporation, not a contractor that's got an LLC and a tax ID number, insurance and all that. I'm not talking about those people, but if you pay an individual on a 1099 to do some work for you, the presumption is going to be they're an employee. And you have the burden to prove that they meet the 18-factor or the IRS test to be an independent contractor. And you think that's kind of interesting because it used to be the burden on them, right, to prove it. And so they flipped it. And that test is actually pretty hard to meet. And it also allowed those people to file an action saying, hey, I shouldn't have been a 1099. I really should have been an employee. And because I was a 1099, I didn't get what? I didn't get benefits. I didn't get eligible for the 401k plan, right? They didn't withhold, they didn't pay the employer share of FICA as an independent contractor. I had to pay that. I'd really like them to pay that now. And when does this come up? Everybody wants to be a 1099, at least a lot of people in the think about the construction industry. Think about A lot of IT type people and websites. Now, a lot of people want to be 1099s when they work for you. They love it, right? Because tax, there's an advantage for them. When do people not like it anymore? When you stop using them. And so now they can come back and say, well, that was really nice while we did it, but I would like a little more now that you're not paying me. And so I'm going to say I really should have been treated as an employee. And this statute is really, really broad if you start thinking about it. Anybody who's not properly classified as an employee, either now or within like 2 years, when they can come back and say, hey, I'm there. And what do you get? Any differential in wages, any benefits they would have gotten as an employee, and mandatorily they get their attorney's fees and costs. So again, plaintiffs' lawyers love this. Even if I recover $1,000, I can get $10,000 in legal fees. It's great fun. I get $10,000 in whatever, man, I get $100,000 in legal fees. And that part gives them a lot of sort of leverage under this statute. Also makes it unlawful to retaliate against somebody for saying, hey, I think I ought to be an employee. And so you think about that test. What does that test look at? Are they out doing this stuff for other people? Are they doing something that's a core part of your business, right? If I hire an individual to mow my grass, that's not the business I'm in, right? I've got an office location. I want to look nice when people come over. I'm not real worried the long guy that you're paying $40 a week to mow the grass in the summer is going to be deemed to be an employee, right? Brings his own mower, provides his own equipment and tools. He decides what time he wants to cut the grass, unless you're a really demanding, customer. All right. He comes and does it and he sends you a bill, and you don't really care how he does it as long as it looks good. You don't care if he uses a pair of scissors or a stand behind mower or right. You don't really care as long as he gets the job done. And it's not really related to your business. It's kind of one of those ancillary things. We're not worried about that guy, right? You hire someone to come in and mount this projector, right? You're not in the business of doing that. We don't care. But if they're coming in and backfilling to help you provide the service you provide your customer, to make your product, to do something related to the opera of your actual, right, your business, well, now it starts to look like an employee. Well, now we say, is there a risk of profit? Well, probably not, right? Probably paying them hourly or a fixed fee. Do they control the method times and all that, right? Are they being subject to supervision by somebody at your place of work? Do they provide their own tools and equipment? Do they hold themselves out to the public and do this for others? They just do it for you. And so that person that's a 1099 that's really kind of just working for you for a few months, they're not going to meet that test most of the time. And so that's where we have an issue. The one that's also out there, I think, has not gotten a lot of interest is they also made this and added to this statute that if you're a licensed construction contractor, that you are required to appropriately classify all workers or employees as independent contractors as provided under this statute. Because in the construction industry, right, there's an awful lot of people work as independent contractors. And if they're a plumbing company, that's fine. If they're a day laborer and they just come work for you and you use them every day when you have a job, well, now we've got a little bit of a problem. And you can actually, if they show that you're intentionally not classifying all your day laborers, all your sort of people, you're not paying them as employees, you can actually get sanctioned by the board and have your contractor license suspended. And they thought that might give a little motivation to construction contractors to comply. And so that's one that I think surprises people. That's sort of out there. So we have, Virginia has always followed this, right? Employment at will. Everybody hears that. Virginia is an employment at will state. And what does that mean? What that means basically is I can fire you for any reason I want. If I don't like men that wear purple shirts, I can say no purple shirts. Purple shirt people, you're out of here. You're a UVA fan, you're out of here. We're not dealing with that. And so you can have really dumb reasons to fire people. And really the exception was you couldn't do it for a reason that violated a statutory right? Violated federal law. You can't do it because they're an African-American or disabled or over 40 or all that kind of fun stuff. And the only thing really outside of that was they refused to engage in a criminal act that you directed them to do. Not terribly shocking. Or they had public policy in a Virginia statute that they're the person being protected by it, which is kind of this wonky, what was called sort of the Bowman exception. But outside of these three things, I could fire people for any dumb reason, good reason, bad reason. Didn't have to give them a reason, right? I just don't want to work with you anymore. Have a nice day. We had a big change to that under this statute because now we have a whistleblower statute that is a new exception to this employment will rule. And let's look at what's under this thing. Reports of violation of federal or state law or regulation requested by a law enforcement officer in person of hearing, don't get that, refuses to engage in criminal activity, that's now a statutory one under the statute, refuses to do anything that violates federal or state law, and the employee tells the employer, that's the reason I'm not doing it, or they participate in an inquiry or a hearing or investigation related to any of this stuff. And you think, well, that sounds kind of reasonable, doesn't it? But what kind of stuff falls under this? I don't think the drill press we have is safe. that a violation of OSHA? Sure. Any workplace safety issue is going to be. I don't think you're disposing of that leftover paint properly. Well, that's unlawful. You can't do that. All this it's actually a little bit broader than you might think, because it's any federal, state law, or any type of regulation. And if you get down here, I think something you're asking me to do is unlawful for some reason. As I have a good faith belief and tell you, well, I don't think you can, you're telling me to fire John. I don't think you're treating him fair. I'm not going to do that. I think that's illegal to fire him for that. They're actually protected in doing that. And so now we have this whistleblower statute that's out there. That's really pretty broad. It's not hard in a lot of situations to come up with some reason why that is unlawful or improper. And we see a lot. The place I'm seeing this in my practice is in the industrial areas where there's a lot of gray about, right, I don't want to use that machine without a guard. Well, if we're cutting wood, the machine doesn't need a guard. Well, I think it should have a guard. Well, that's great. But our industrial safety guy doesn't, and it slows down operation. I need two guys to run the wood if there's this, thing on it. And so we're seeing people use it in those situations a little bit. And it has a really broad thing of what they can do. If you violate that whistleblower statute, pretty short time period to bring a claim, reinstatement, no cap on wages that can be reimbursed, no cap on attorney's fees. It's a pretty broad statute. So the next one we get to is non-competes. And this, we're going to talk about the state statute, but I'll predicate that. I didn't put it in the federal part because it's not in force yet, but most of you have probably seen the FTC has released a rule attempting to basically outlaw most non-competes that aren't related to a sale of business or very senior sort of executive. So for most regular people, it would get rid of non-competes completely. There's litigation going on to try and block that. And depending on who you follow, who knows, right, what the outcome of that. I mean, they've tried to do some of that stuff before, and it's been challenged. The administrative deference, that Supreme Court case that overturned what was called Chevron, where administrative agencies got a lot of deference in making rules and whether they were authorized under the statute. This one may get killed by that. I think there's a decent chance the federal law goes away. They really tried to show it as a really thoughtful rulemaking. When I pulled up the rule to look at this, I thought, well, I have several clients who came, yeah, can we touch base on that? I just want to see how that impacts. Oh, yeah, great. Yeah, we'll catch up tomorrow and talk about it. Then I pulled down the rule. Has anybody looked at it? It's over 500 pages. I don't mean like with exhibits at the end or they attached a bunch of reports. The literal rulemaking itself is 500 pages. They tried to cover every reason somebody could challenge it as being, right, an arbitrary application of this rule. I mean, incredibly. I mean, whoever, it's kind of nuts that way, which I think they thought would allow them to do it. That was done before the Supreme Court case said, hey, let's rein in these administrative agencies out there making rules where Congress didn't pass a statute. So that federal one, I do think, is in play. I'm going to be a little bit surprised if it doesn't get blocked. But, a lot of people thought that FLSA one was going to get blocked. But I think this has a higher likelihood at the federal level. But that doesn't affect that we have a state law. And Virginia is now one of, 12 or 15. There is a growing trend of states of adopting protections for what they call low-wage employees. The idea, and this was the joke when these started around these different states, was that it was the Jimmy John's rule. And I don't know if any of you saw that. There's a bunch of litigation. Jimmy John's, believe it or not, until a few years ago, made everybody sign a non-compete as if there was something really secret about how they made a sandwich, that they didn't want you going down the street to Subway and sharing. I kid you not. And the people said, this is ludicrous, right? That a sandwich maker is having to sign a non-compete or somebody in kind of some of these kind of jobs. And so they said, how do we fix that? And they thought, well, the easiest way to fix it is let's set a salary threshold, right? If somebody's really valuable, if you're investing a lot in them, if they're making hundreds of thousands of dollars a year because they're developing technology for you, yeah, you can go do it. But these low wage people, and who thinks that kind of makes sense? I mean, I'm a management side lawyer and I think that makes sense. What would you? And we'll see. And there's actually some legislation going on in Virginia to specifically address physicians and some stuff in the medical field. And I think that may pass next year. Yeah. And the idea, you think the logic of why they don't allow them for lawyers is, all right, I'm your lawyer. I'm in the middle of your case and everything about it. We got a relationship. You trust me. I've represented your business for 20 years. I get fired from my leave. When I leave, whatever reason I leave, right? Now, all of a sudden, you can't use me anymore, and you've got to pay someone else to get up to speed on something, and it may cost you tens of thousands of dollars for them to take over a case in the middle of the darn thing. You're kind of in a bad spot, aren't you? Well, that doesn't make it. That was the rationale for saying, hey, that relationship goes above economic, right? You're an officer of the court. You've got all these duties to all this stuff. I can't withdraw from representing you, and a lot of times just because you don't pay me in the middle of a case. If I've got a trial up and I can't just say, well, I'm not going to do it. I need some more money and leverage you. The court has to let me out, and I have to go to the court and get the court to decide that it's okay. Otherwise, I got to go try that case for you because I've got a duty to the court, right? And all these things. And so the idea was that, well, how does that not apply to a doctor too, right? I mean, they just didn't have to go to lobby as the lawyers did. So this one basically picks up and says, any agreement entered after 2020, and basically says you can't enter into, enforce, or threaten to enforce a covenant against any low-wage employee in Virginia. And that's the law in Virginia. What do you?
Apply to-
Well, it's a great question. Are they really an independent contract? So you immediately have that argument of, do they meet it? Because if they meet that classification test we just talked about, you may be able to still have it in a business arm's length transaction, right? If I hire somebody to help me with my business and I say, I'm going to do this, but I don't want you, right, doing a marketing plan for my competitor next door tomorrow, right? So you can do that in a business context, but it has to be a real business context. If they're really an employee, right, but you're paying time, that doesn't get you out of it and might cause another problem. But what do we think is a low wage employee? What should the cutoff be? So they decided to tag it to kind of the medium or average wage in the Commonwealth when they passed this back then. You might have noticed that a couple things happened during COVID. The average wage actually shot up because professional and jobs could be done remotely, right? Didn't get impacted as much as hourly jobs. And we've had this little inflationary issue that's been doing it. And so what do you think the cutoff is? Anybody know?
15 now.
We wish. The current one, it's over $70,000 a year. And people are always surprised. They think low wage employee, they think, oh, well, in our part of the world, it's 30 or 40 million in Boston, but it's they go through and do this. And so you look at that, we've got this idea of anything that's kind of what you would think about as a covenant not to compete, or you don't go solicit our, customer and all that. And so it's got all those provisions. And then we go down here and say, well, what is it? And that average weekly wage in the Commonwealth, it's not this high in Southwest Virginia, I can assure you, but we're picking up Northern Virginia and all the government employees and all the folks in higher wage areas where there's a huge hunk of population. So the current average wage for this year, the number is 73,320. It'll probably go up next year. And so pretty soon that number's going to be clipping up at 75. Anybody below 75,000 a year under state law, you can't have a non-compete. And it's a violation of the statute to try and enforce it or to enter into one with them. And so people are playing catch up on kind of understanding that. It does include an individual. So this is the part where it picks up. Are they kind of this service independent contractor? Are they really a business? And so they say an individual independently contracted to perform services, independent employment, compensated at an hourly rate, and all that kind of fun stuff. And that one's a little north of $20 an hour. It was a little lower before. It's kind of been moving up a little bit as that other number moves. And so we have that out there as well. And if they're above that, for that person, you can exempt them, but you're going to have that same issue of sort of looking at whether they're under or above that cutoff. And we've got some litigation going into this now. I've got a case pending up in Roanoke, and the fight is the statute says enter into. Yeah, okay. Well, when they entered into the contract with the guy, he was making $60,000 a year. Who was below it. Okay, we can't enter a contract. That got to be unlawful, right? He got bonuses, and by the time he got left a couple of years later, well, he was maybe just above the threshold. Is that guy covered? Is he not covered? And there's a real problem because they wrote the statute really quick and put it in here. And the only definition they gave of who is a low wage employee is basically what were their earnings in the 52 weeks before they left. And if it's less than 52 weeks before they got terminated, then we'll look at that shorter period and come up with an average number. But it didn't give any definition of how you calculate it at the time they enter into or when you threaten to enforce it. And so the courts are like, what the heck do we do with that? So it's not a very well-written statute, but it's out there and you want to be aware of that issue. I mean, the good news is most time if people are going to enforce it, they come talk to the lawyer and we say, hey, you got a problem. Let me see here. We'll get jumping over. Yeah, so that's other. It does not affect having a confidentiality agreement. Don't use my IP when you leave. Don't take my documents. All that stuff you can still apply sort of to everybody. So does allow people to bring their own cause of action. But here's the interesting one here. If the Department of Labor does an audit and you have restrictive covenants with a bunch of people that you shouldn't, they can fine you $10,000 for every employee that you have an unlawful agreement if they come in and audit you. And so if you've got, 15 salespeople that you've got signed to a non-compete that are covered by this statute and are below the number, you got a problem. That's going to be an expensive letter you get back from the Department of Labor. There's even a posting requirement. I don't see this enforced a lot. If you buy your posters from one of those services, you're going to get this added to your poster now. If you don't, you can print a copy of the thing. There's an online one that the state has, and you can tack it on your bulletin board. But you can actually, if they come to an on-site audit, they'll come look at your posters and see if you have it, and you'll get a fine if you don't. So think about all that fun stuff. So private cause of action just means not just the government can come after you for violating, but the employee can sue you as well. And this is a big one. So look down here, right? If it's a knowing violation, you did it anyway, you can get treble damages. You get all your attorney's fees. You get your lost wages. You get prejudgment interest. I mean, it's a pretty strong statute. And so we've got that out there. The last one that we're gonna touch on, sort of on the Virginia side, is this pay transparency one. And this is an interesting one. I've had this come up more than I really would have thought, which is this idea now that employees, right, are allowed to do what? Talk to other people about their wages, right? Well, what are they paying you? They're only paying me $22 an hour. Are you getting whatever? I don't think I'm getting treated fairly. You can't fire somebody for talking to their coworker about what they earn. How about that? And so
You could do that before people.
you could, yeah. You could actually say, and not lots of handbooks. I still see handbooks I'm reviewing now that say that's confidential. You don't discuss it with other people. That's between you and us. And don't do that. And now it's protected. And there's actually the Department of Labor on the federal level has said for employees that are eligible to be in a union, non-managerial employees, that protection applies at the federal level under that statute as well. But this applies in Virginia basically to everybody, which is kind of surprising sometimes. There are some carve outs. If you have information about it because you work in HR or you're the office manager and you know what everybody makes, you can't then go talk about what everybody makes to everybody because you don't like what the employer's doing, right? So there are some protections there, then some limitations, but it's pretty broad. So how we feel? Feel pretty good? Pretty good?
Your job is safe.
Yeah, this is the Jim needs to hire another employment lawyer law. So trust me, it really is. So the last part, we're going to take our last few minutes here, last 15 minutes or so, and kind of go through our little top 10 list. And my view is really more just to get these out there, that if there's one that piques your interest, we'll sort of talk about it. So, do you have a written sexual harassment EEO sort of policy? If you don't, or you haven't updated in a while, you really ought to take a look at it, because the one you had from 1998 is probably not compliant with the law. And really where most of them fall down is on what your duty to investigate, take prompt, adequate action, to tell them they're going to be protected from retaliation. There's a bunch of things like that you have to have. Your policy can't just say, we don't discriminate based on this, have a nice day. And you used to see a lot of one paragraph ones. You need to tell them, if you bring a concern, we'll investigate it. You'll be protected from retaliation. You have to tell them all that stuff. Obviously, once you hit 50 employees, you need to start providing FMLA leave. And sometimes we see people clicking above that. And basically, you're covered once you're above 50 employees for 20 weeks in the calendar year. And then you're covered for a year. And if you drop back below, you drop out. But there is a calculation sort of for that. Handbooks are an interesting one. You want to have a disclaimer on it that says this isn't a contract of employment. And generally speaking, Virginia courts have said they're not. It's just a bunch of policies for the employer, but it's good to put that disclaimer in there. Where I've seen people get into trouble is I write an offer. I've got a handbook, and I write you an offer letter that says your employment is subject to the terms of this handbook, or some fancy language like that. And you need to sign here that you're agreeing to blah, blah, whatever. And you think, well, all right, if that's a condition, now does that get to be a contract? Well, most courts have still said no, but some have said that's a closer call, depending on what you told them. And then we have people that actually have an employment contract. And we see employment contracts where they incorporate the employee handbook and reference it. Well, now we really got a problem. And so you do want to make sure you're not creating a contract, because you want to be able to change stuff when you need to, right? And make exceptions and manage your business. Employment applications, that's one where I still see people using really old employment application forms that do stuff that you're not really allowed to ask about. They're asking about arrests. They're not following the right language about immigration status. I mean, you see these old forms that people got, they got one somewhere and they had a big stack of them and they just keep using them. Be cautious about that because a lot of this stuff, as it's changed over the years, will control sort of what you need to have there. The other is if you require people to apply online, which is becoming very common, even for employers that aren't huge, right? They're trying to drive it through a portal. They're trying to use some sort of process. If you do that, you have an obligation to provide accessibility to folks that have disabilities so that they can access that. And if you don't do that, you can have some issues. And there's a cottage industry of lawyers who are suing employers for website accessibility. I've had 4 of those cases in probably the last 4 or 5 years. I've had hotels sued for their website not being accessible for somebody trying to make a booking or a reservation in the restaurant or find out what amenities are offered at the hotel, and their website doesn't have the tools built in to make it accessible to someone that's visually impaired, for example. Or there's a video that talks about it and there's someone talking, but there's no way for someone hearing impaired to get that content. And if that's relevant to the service being offered, that can actually be a violation. So the same thing applies. I'm trying to apply for a job. I can only do it online, but your online thing is a PDF and I'm visually impaired and it's not coded. It's not a PDF that's coded so that a reader can read it. There's tools that allow those folks to access. And so we've seen that. I've had banks sued. I tried to open an account and I went online and I couldn't navigate through the website. I couldn't do it as a person with some impairments. And so that's out there. We see that sometimes. Severance benefits. This is an interesting one. I'm actually a fan of this. Not all lawyers are. You can get people with lots of different opinions about when it's a good idea to have a severance agreement and pay somebody a little money to move out the door. I often take the tact when I talk to people is, well, you decided you needed to move along when, and they say, well, shit, I probably knew a couple of months ago, or I should have done this too. I mean, how often have that conversation, right? Because nobody likes doing it. I don't like doing it. I've had people who aren't a good fit and I wait an extra 6 months just hoping something will happen. I don't have to deal with it, right? We all do it. And I still need some help tomorrow. So I'll just wait and push the thing down the line. So if you're going to do that, and that's the situation you're in, well, just pay them 2 more weeks, right? Do something to help this person move along and you can get a release and cut down having to pay me or the risk of a claim. And particularly if it's there's some tension or some issues about, some dispute about performance or all that kind of stuff. But there are a bunch of requirements for those. If they're over 40, there's a disclosure requirement you got to make. You got to give them 21 days to review the agreement. You got to give them 7 days to revoke it. There's all kinds of stuff in there. But the bigger one that I'm seeing people get into trouble with is for employees who are not managerial or kind of professional employees that are sort of your hourly or your regular folks. The Department of Labor has taken the view that confidentiality and non-disparagement provisions violate this idea of allowing employees to talk about how they were treated, because that would prevent that employee from going and talking about how badly you treated them. And maybe they'd want to come together as a group, right, and say, hey, this employer's not doing stuff. Maybe they'd want to form a union. Maybe they'd want to collectively negotiate with their employer to address a safety issue, whatever it might be. And so if you have these, and I used to write them all the time before this rule came out, I want that confidential as tight as it is, right? You tell anybody anything, I want my money back. I was right. I mean, they were very tight to try and, and a lot of it was what? I don't want to get badmouthed on social media. I don't want you posting on Facebook and TikTok and everywhere else, trashing my company when I just paid you a month's pay because things didn't work out for whatever reason. You got to be really careful with how you write those now. You can have things about defamation and all that stuff, but for non-managerial employees, there are pretty stringent limitations on that. And if you violate them, you could end up getting sued by somebody, even though you had that person sign a release. And so that's become a big issue. Credit checks or background checks. This depends sort of what you do. If you use a service, right, to run a background check, there's all kinds of online ones that you can use. Your employer, you have to check a box saying you're doing it for an appropriate reason, but they'll run a background check for you. But most of those background checks really are what? They're covered by the Fair Credit. Yeah, they're basically a type of credit background check. It includes some of that information. And so they're covered by what's called the Fair Credit Reporting Act. And so if you use that service, you've got to tell people and make a disclosure about it. And the disclosure has to have very specific language and tell them what their rights are. And guess what? If something in there is the reason you don't hire them, you got to tell them. And people fail on that all the time. They get it, looks bad. You say, well, just don't move that forward, get rid of that one, we'll move on. But you actually have to tell them. And the idea is you tell them, you give them this notice, it has the information about the services, right? You can go back to these credit agencies because maybe it's wrong. That bad thing that came up on my credit report is not this Jim Cowan. It's a different Jim Cowan that shot somebody at work and went to jail for 8 years. It wasn't actually me. or that credit thing, I go to work for the bank and this terrible credit thing is actually some other person, right? Or I'm a victim of identity theft, whatever it may be. And so you got to give those notices. And I see small employers, practices aren't real formal, right? So they go online and do it. Or somebody says, hey, you ought to run a background check on this person. They're going to have access to the bank account, and they don't follow that process. And that can be a big problem. So record retention, you do have to keep payroll records for 3 years. If you have any workplace injuries, you got to keep those records for 5 years. If you offer benefit plans, you got to keep those for 6 years. There are some record keeping things that you have to do. And they're different by statute. Can you pick just really long time? Yeah, some people do. We just keep everything. I mean, no problem there. Is that a great idea? Well, probably not, right? So take a look at that. You can find some pretty good lists on that. If you need a record retention list, let me know. I've got one. I'll share it with you. Accommodating disabled folks. Make sure you're thoughtful. We talked a little bit about that earlier, and so I don't want to take all of our time to do that. IP. With all this stuff about non-competes and all those fun things, you do still want to have confidentiality clauses for people that are going to have information that's actually valuable to your business, your customer list, your pricing on your contracts. If you've got stuff that you wouldn't want your competitor to know, there's 2 ways you can get protection for it. Everyone guess what they are? Right? You can make them sign something, right? You can agree between you and me what things are confidential in our business, and she can agree that she won't use those things after she leaves. You won't take them with her, you won't download them, all that kind of fun stuff. And so that's the best protection, because the other protection is what? That it meets the definition of a trade secret. And that's a statute. Almost every state has a definition. Virginia has the Virginia Uniform Trade Secret Act. But the problem under that is, as the employer, you have the burden to show that you treated it as a trade secret and what steps you took to protect it, and nobody that didn't need it had access, and could people get it? Was it insecure? And you get into having to prove that it meets the definition of a trade secret, which is probably a higher bar than us just agreeing between ourselves that everything on my customer list is confidential, right? So you want that. And then also you have the flip side of, have you done enough stuff? And so when people get sued under that statute, the lawyers end up spending a lot of time fighting about, how protected was this stuff? Was it in a locked file cabinet? Who had access to that office? Was it left on the copier? Were there protocols where it was only printed on a copier in a secure area? I mean, it gets down to that. And most of us in small businesses aren't doing that. Big employers have protocols for some of that stuff, but most of us don't. And so you want to be sort of thinking about that. So the last one is training, right? What kind of training do you do about employment laws? And I tell folks, once you start to click up where you've got 10, 15, 20 employees, you ought to be thinking about doing some annual training. Does that mean we need to spend 2 days training everybody and lose all the protection? No. Do you get bonus points for doing a really long sexual harassment training where we go off site for a full day? Well, no. But do you get a lot of value and protection as an employer from spending 30 minutes telling people what the policy is, what the complaint procedure is, telling them, hey, we take this seriously. And if you have an issue, come to us before it gets serious. Those things do provide protection. And when you start talking about those types of claims, one of the things to get a defense, so if I fire you because of your gender, and you can show that that was the reason, right? Or I refuse to hire you, right? Well, there's gonna be a lot of travel. You're female, you have young children, so I'm just not going to consider you. I've done something that caused economic damage to you, right? You didn't get this good job because I made a judgment about you based on your gender that wasn't fair. Well, maybe your husband's a very good, maybe you got plans, not mine, figure out your plans, but I can't, right? That's discrimination. Can't do that. And so you think that kind of thing with that immediate economic harm is a strict liability. If you're an employer, you do it, you're going to be on the hook if they show up for the damages. But most of the cases that we deal with today, most employers know that's really dumb. If you do that, you're probably going to get sued and it's not going to come out real good. Still happens some, but most of what I deal with are what? More of that hostile work environment, right? A coworker saying another coworker's acting inappropriately towards them, right? Or engaging in unwelcome advances, or saying racially, offensive things, or saying things, right, that are misogynist. Take your pick of what, right? And people can say all kinds of people. Some people don't have real good judgment, and we see a lot of that. And so in those situations, what's the problem with that? All right. Most people, if they're going to sexually harass somebody, they don't do it during this training while everyone's here, right? Because it turns out that you're probably going to get in trouble pretty quickly. When does it happen? Right? It happens when it's just the two of us over by the coffee maker, or we're on our way to go to a client meeting, or we took a client out to dinner and we had drinks and then I'm driving the person home, right? It happens in those situations where there's, right, a lot of he said, the employer may not know what's going on, and it may go on for a while. And so if you have a complaint procedure and you train, the statute says if you have a policy, You actually follow it. You tell your employees about it. You train them about it. You tell your managers, you tell people, if you do this, you're going to be subject. And you actually investigate when people come bring a concern. There's actually a provision in the statute now under the law, and it's been this way, gosh, for almost 20 years now, but it doesn't get as much place sometimes. So if you do those things and you do that training, if the employee doesn't come to you and say, hey, I've got a problem, right? They wait until they're gone or they leave. And then they say, well, the reason I left was there was a hostile work environment. I was being sexually harassed by my manager, by my coworker for the last 5 years. I just couldn't deal with it anymore. I'm going to sue you. And they say, well, wait a minute. You can't do that, right? You didn't give them notice and a chance to fix it. And they may not have actually known. And the exception then is you've got to show that they were on notice of it, actual or constructive knowledge, right? You did complain, you did say something, or it was so obvious you saw it going on, you just didn't do anything. But if it doesn't meet that, and you don't give the employer an opportunity to address it, then you're not going to be able to sue them. Now, the flip side is, and the other reason you do that training and want to talk to your managers and your supervisors is, basically that law says, hey, if you don't know when they come to you, as long as you take action to stop it and prevent it from reoccurring, there's no liability for the employer because you can't control what everybody, right? I mean, you can't control if you're a bank that a customer harasses or acts inappropriately or says racially hateful things to one of your employees. You can bar them from being a customer if they do that, if you find out about it. But it's this idea of notice the employer and that chance to fix it. And then the liability attaches what? If you don't fix it or you allow it to reoccur. And then they say, now you got an issue, employer. And so you want to make sure you're getting the benefit of that. And now that this broader state statute has kind of trickled down to our smaller employers with, pretty significant exposure, I always want to make sure, hey, give yourself the benefit of that, right? Because in all candor, the most likely of those kind of claims as one employer you're going to get is one of those type of, right? Smaller employers tend to be more informal. They tend to, be more team-based. They tend to do a lot of stuff outside of work. They tend to go out for drinks more to get, all that stuff. Well, what are all those? They're all opportunities to have things happen in the work environment that are offensive, that are unwelcome, that are not appropriate. And so you want to make sure you're getting the sort of the benefit of that. And that's kind of the best way to do it. So that's my speed dating version of everything you want to know about employment law. That you want to be aware of, the good and the bad. Some of those are nice for us. Some of those, but you want to have some awareness. I think they're going to share a copy of this so you can have those slides to look at. I think we've got 3 minutes for questions even still. So we didn't do too badly. Yes, sir.
Real quick, just go back to reasonable accommodation.
Yep.
So you had said that, if somebody were temporarily in a wheelchair or whatever, and, does that account for off work or non-work?
So it does. So the test is it a disability, meaning a long-term or serious impairment is going to have stuff. So if I break my arm, but I'm going to have a full recovery and no limitations, that's generally not a disability. And if it's a work-related injury, right, I'm going to get some workers' comp. But if it's outside of work, there's really no protection for me. If I can't work, tough luck. You can give me leave if you want, but you're really not responsible for accommodating that. On the other hand, if I'm in a car accident and I'm going to have some permanent limitations and injuries, or I'm in a wheelchair because of some genetic, some other issue, then it doesn't matter if it's work related or not. You've got to go through that interactive process and say, is there an ability for this employee to perform the essential functions with or without some reasonable accommodation? If there's something I can do to allow them to perform the job, then I got to do it. If there's not, then you say, unfortunately, there's really nothing I can do. If it improves, you can do it, great. But otherwise, and the interesting one is a question I get is about light duty. So if you have a workers' comp claim, you've got a big incentive to bring someone back, even though they can't do all this stuff. And so you want to do that because it lowers your comp exposure and the cost to the company and your rates long-term and all that fun stuff. Do you do the same thing if it's an outside, right? My injury is not a workplace injury. I wrecked my motorcycle last weekend. And some employers, they want to do that. And I tell them, let's really talk about that. Because once I open the door and say I can start making accommodations for non-work related injuries that are somebody not able to perform all their job duties, well, I can't do it for Kelsey and not do it for you. I've got to be willing to do it for everybody that's similarly situated forever, pretty much. And so you want to think about that. And what can I really do? And then you also have to have that conversation of, is the thing they can't do an essential job duty or not? And the example I give folks a lot of times is, I've got a legal assistant, paralegal, sits at the front of our office, answers the phone, greets everybody, all that stuff. And, you might know, even in today's age, we kill a lot of trees in our business. I mean, we print a lot of stuff. So we get deliveries of paper and, they come in those big, case boxes and they're somewhat heavy. And so, maybe she can't lift that and put it up on the shelf where we put it because our stock room is pretty small and we kind of stack it up there. Is that an essential job duty for her? Well, probably not, right? Can somebody else do that? Is that the reason I hired somebody? No, she's there to greet clients, send out bills, make appointments. And so it might be an accommodation, just have someone else put that up when it comes in, or to let her sit it on the floor till someone's around, right? On the other hand, if she's a receiving clerk of those boxes and her whole job, right, is to get them off the truck and move them inside, well, now it is an essential, function. And so you got to look at that. If it's a non-essential function, you probably have a duty to figure out some other way to get that done in your workplace. But if it's a key reason that they're there and it's a part of the job that they really need, or there's no one else available to do it, that can be a reason as well, right? If they're the only person in that office, you got a better argument. And so there is a big differential between work-related non, but the cause of the injury doesn't change your obligation if it really is a permanent impairment or disability to determine whether there's stuff you can do to allow them to do all the things that are essential parts of the job. If that makes sense.
The second part of that is, I go to CowanPerry.com.
Yeah.
And I have immaculate degenerative
Yep.
eyes or whatever, and I can't really read it.
Yep.
Is it your responsibility to put a verbal or a vocal?
So this is where all this litigation gets into. And the answer is, who the heck knows? Now, I mean, it's all over the place. And so essentially, on the government side, under the Rehab Act, which applies to people doing stuff in government services and all that stuff, it specifically refers to what are called these WCAG, which are it's a nonprofit group that sets website accessibility standards. And there's different levels of accessibility and stuff you do, right? Is there a voiceover? Is there all this fun stuff? That has not been adopted under the ADA, although most of these lawsuits, they claim you don't meet it because there's all kinds of tools and software tools that will test a website. And so these people that are trolling around for this, they go and run those tools and say, aha, that business's site failed, right? We can target them even though. And so basically it says, if there's other ways of accessibility, right? So I can have someone that says, hey, if you need help, call me and we'll set up a phone interview. If you have any issues with this or need accessibility accommodation, let me know. Generally speaking, the statute doesn't have specific requirement. If you provide alternate means of accessing the information, of contacting me, of applying for a job, all those fun things, that generally should be enough. But I always tell people, if you're doing much volume of anything, it doesn't necessarily protect you because all these people are saying, well, that's not enough. You need to be, these standards really are the test because they've been adopted in these other contexts and you need to meet them. And they're not that easy to meet if you get down into the weeds of it. Now, most website developers and people now know how to do that. And there's people who will look at your website and say, here's the 4 things you need to change to be at a level 2.0 or whatever it is. And you can do those changes. And the problem I see after that is people start changing and they add content to the website and they do things right that then are. And so most of the ones I've had are somebody, particularly if it's like a larger employer that does a lot of online stuff, like a bank. I've had 2 or 3 of these cases for banks that we represent. And the site was compliant when the people built it. But then over time, you've got people internal to the company that really aren't accessibility experts, updating the site, adding content to the site, uploading documents that are linked to the site, putting a loan application form online. And it's not programmed to give that accessibility option. And now we have a problem. And so that kind of stuff, it gets into a very sort of challenging level of detail. And the thing for small employers is like, where on that curve do you get? If you look at my website, is it perfectly accessible to that WCAG most current standard? Probably not. Do I worry a lot about it? No, not really. If I was a bank and people could apply for a car loan there, if I was a hotel, right? If I was, that sort of thing, if I was selling a product to the public, the other thing they're going after are these online retailers, because there's some court cases that say there's a big debate among the courts of, if I have a retail store, but you also have an online functionality, is that really just an online ad? You can come into my place of business and I can accommodate you and serve you. Am I covered by this reg? Some more conservative courts have said, no, that statute's really about it was designed to make sure you have a ramp out front, that I can get into your store if I'm handicapped, right? Or that I can get service if I'm hearing impaired or whatever it might be, right? I go to the football game. Is there an option if I'm hearing impaired to get service, whatever it might be? And it really wasn't intended for these websites. But there's a group of courts that's a pretty decent number of them that have said, if the only access to buy your product is online, then these need to apply to that because there's no alternative for me to buy your product or service. And so if you're purely an online retailer, I think you need to take it probably a little more seriously than if I'm a little retail thing, you really don't do business on my website. It's just informational. I don't worry a lot about that. If I force people to apply for a job through it, or I'm selling the product over it, then I worry a whole lot more. I think your exposure is going to be much higher. All right. Any other questions? And if you have a question that you didn't want to ask in front of everybody because you're embarrassed, my contact info is on here. My view is if you've got any follow-up question about something we talked about today, because I talked really, really fast for an hour and a half, just call me, shoot me an email. We've had people the last couple of times we've done that reach out. We're happy to take 10 or 15 minutes, talk to you, explain it, try and give you a little bit of guidance specific to kind of what you're dealing with. And we appreciate the opportunity to come out and visit with everybody.